G'day everyone and welcome to topic 8, tute for T3 2016, which sounds really weird because we're now in 2017. And this week we're going to be looking at confessions and admissions as exceptions to the hearsay rule. I'm not going to start by talking for terribly long about assignment number 2. I will just remind people that it's out there. And so I hope everybody is working on it and everybody's enjoying the movie. Does anybody who's here have any particular questions that you'd like to ask me about assignment 2? All right. Well, the one thing that I want to add that I'm not sure I emphasised enough last week, and even if I did, there's no overemphasising this. Some students go wrong with this assignment because they end up not providing references, not providing authorities for statements that you make. It is absolutely vital that you provide me with authorities so that when you're making statements about the law in relation to those questions, that I can see what authorities you're relying on. So the fact that it's kind of not a normal assignment, don't let that get in the way of the fact that you've still got to be able to show where all of your points of law come from. So please, if you're on the point of being ready to submit and you haven't got any references in, go back and find them and add them. So confessions and admissions this week. Well, let's start by asking the obvious question. And I'll ask it of Martin, what's the difference between a confession and an admission?
Strictly speaking, there's no difference, but confession is generally treated to be an admission in a criminal matter, whereas an admission is in a civil matter.
Yeah, now where else do we, that's exactly right, Martin, I'll move on from you. Where else do we come across the concept of a confession, Peter?
Yeah, I was going to say criminal law, but maybe in a church.
Yep, that's exactly right. Now, what is a point of it? Can you think of any points of evidence about confessions in church that sometimes might be raised in terms of evidence law?
Well, it's kind of like a client privilege relationship, I guess, between the priest and the person seeking to give him a confession, but I can't conceive of too much else.
All right. Now, is there a privilege? Is there a religious privilege? Jason, what do you reckon?
I think that's a really difficult question to answer. I think traditionally you'd have religious people saying, absolutely, I can tell Father Joe, but I had 2 banana ice splits last night and, confessed my sins. But I think realistically, there'd be exceptions. If it's a criminal matter or something, I think a priest would almost be obliged to report it, wouldn't they?
Well, you'd think if we take the worst case scenario, let's say that a terrorist had planted a bomb in a public place and they then went into a confessional and said, oh, Father Bob, I've just planted a bomb in a public place. Aren't I terrible? And if Father Bob's response was to say, well, go and do some Hail Marys and everything will be all right, rather than for Father Bob's reaction to be getting on the phone to the police, be uncomfortable, wouldn't you? Don't you think, Jason?
Look, in my personal opinion is Father Bob has got no right whatsoever to keep that privilege. He's got a duty to inform that. Like he's not a judge by any means. I don't think he has to report it. Same as I guess if there was some sort of sexual abuse of children or something. Realistically, it's got to be reported. I'm sort of semi-religious myself, but bad luck. You can't keep that stuff quiet. That's only my opinion.
What does the law say, Martin?
They're entitled not to divulge it.
Under which act?
The Uniform Evidence Rules, Section 127.
So, in the Uniform Evidence Act jurisdiction, so in the Commonwealth jurisdiction in a Queensland context, clergy are entitled to refuse to divulge religious confessions. Now, let's unpack this a little more. There's an exception to that exception. So if the confession is made for a criminal purpose, okay, if it's made with the intention of furthering a criminal purpose, then the privilege doesn't apply. But there's a couple of other things that we can unpack in that section if you all have a look at it later on, section 127. The first thing is it only applies to religious confession according to ritual. So if you're just sitting down and having a chat with the priest, the fact that you're talking to a priest doesn't make a confession. Okay, so for those of you who are Catholics, you would have to be actually engaged in the sacrament of confession, what I believe is called the sacrament of reconciliation. I'm not Catholic, but you would have to actually be involved in the sacrament in order for the privilege to apply. Now, many other churches don't actually have an equivalent sacrament, do they? And so the privilege would not be available. Now, the second thing about this is that this is a privilege that attaches to the clergy, okay, the clergyman or clergywoman. They can choose, so they're not prevented from making the ethical decision that they need to give this evidence. Okay, they just are not forced to give the evidence. What about in the common law, though? What do we reckon? Anyone know? Jessica, I haven't picked on you yet. I'll start picking on the people who are hiding behind the grey boxes soon. What do you reckon?
I think there is no privilege in the common law.
You're right, there is no privilege. But what you will find is that because the common law grew out of religious law, grew out of religious institutions, it was kind of almost one of those things that seemed too obvious to need to be written down. For many centuries, it just seemed so obvious that no judge would ever threaten to send a priest to jail for refusing to divulge the contents of a confession. It just seemed really so obvious that nobody bothered to write it down. And so in the common law, there's no exemption, there's no privilege. But you'd kind of have to think really carefully, wouldn't you, before calling a priest under those circumstances, or a nun or a clergy person of some description. You'd kind of have to really think, is the evidence that I'm going after going to be worth what are really quite disrespectful religious consequences for those people who are involved? Now, the only reason any of this matters is because there's a hearsay exception. A hearsay exception for confessions and admissions. Let's start with the rationale. Why should confessions and admissions be different to other hearsay? Why should confessions and admissions be a sort of a hearsay that we actually want to get out in court? What do you reckon, Heidi? Looks like Heidi's not with us. What about Vanessa? Let's look for a rationale.
If you were to say that confessions could be publicised or divulged for any reason, you would discourage people from undertaking that ritual, which some may argue may be an infringement upon their right to practice an important aspect of their religion.
Sorry, let me come at the question again, because I don't think I've asked it well enough, because I can see you've answered the wrong question, but I think it was a problem with the question, not the answer. We've got this rule that says no hearsay. Okay, we've got this rule that says hearsay is inadmissible. But then we've got an exception that says confessions in the criminal sense and admissions are admissible, even though they're hearsay. So why should this sort of hearsay be okay for court if other sorts of hearsay are not? What do you reckon?
I think it's because of the basis of why it's being shared. It's being shared for other reasons, not as a matter of facing criminal consequences.
Okay. Anyone got anything to add to that? Why should confessions and admissions, we're talking now about criminal confessions, not religious confessions. Melissa?
Because people who are making confessions or admissions are normally making the statements against their own interests, and therefore they're normally more reliable.
Okay, now that's true. But that's more or less straight out of the notes. Let's unpack that a little bit. I'll stay with you, Melissa. Why would a statement against interest be more reliable?
Because people normally talk about themselves positively. They're not going to willingly say negative things about themselves that may get them in trouble.
Okay, so as a general principle, if someone is saying something that is to their own disadvantage, we assume that it's more likely to be true. And so that does away with the key disadvantage of hearsay, doesn't it? Because the key disadvantage of hearsay is you can't really believe this stuff because you don't know who's saying what. It's just Chinese whispers. But if all of a sudden the confession or the admission is being made by the person and it's negative to themselves, well, then maybe it's something we can believe. Who's not convinced? What sort of circumstances might lead people to say things that are against their own interests, but not true? Jessica says boasting. Now, tell us about that, Jessica. Why would boasting be negative? And boasting is normally positive.
You might hear of, I don't know, potential criminals trying to be more impressive to other people, saying things that they have done when maybe they have or they haven't. Trying to
keep going. Yeah, you're on absolutely the right track. Sometimes people want to try and get a bit of a rep, don't they? They want to try and seem more badass than they really are. And so people might suggest that they've done things bad, when in fact that might not actually be true. So that's one possibility, is that somebody's trying to inflate that sense of bad ego. Now, a number of people have talked about duress. Viv, what do you reckon? How does duress work? Why might duress make somebody make statements against their own interests? Yes, Vivian.
Sorry, I was just trying to find the right switch.
Oh,
wouldn't it be like the in the name of the father confession, where the guy got there and threatened to kill his father? That's your sort of duress because you've got the threat there.
Yep, absolutely.
He just, because that character actually signed it and he said, you can fill in whatever you like above it.
Yeah, exactly right. Now that was a particularly bad case, but who's ever been into a prison or even into a watch house cell? Is anyone here? Do we have any ex-coppers here or anyone like that? Jamie's been into a prison cell. Now, was that an active prison at the time, Jamie?
It was a remand centre. Sorry.
Now, when you say you visited, you would have visited the visitor centre then, or did you visit the actual cells?
No, I've never seen the cells. It was just the visiting section.
Okay. I've been into prisons and around the prisoners, and I've got to tell you that on their own, without anyone doing anything, cells, whether they're in police stations or whether they're full-on prison cells, are really scary, horrible places. Now, if a police officer puts you in a cell and says, you're not going anywhere until you tell us what happened, there's going to come a point, isn't there, where you're just going to be prepared to say whatever you need to say to get out of there. Don't you think? So the moment that we start applying negative pressure to somebody, the moment we start applying duress, sorry, Kelly, you went to Boggo Road while it was operating as a prison, did you? Are you able to come on mic?
Yes. Hi.
Hi. Now, tell everyone about the way that fear just seems to be sunk into the walls of a prison.
It's a very overwhelming experience.
Mm.
Yeah. There's a lot of anxiety just visiting, really.
Really, from the moment that you go through the door, isn't it? There's a sense.
I felt like a bit of a criminal myself.
Yeah, there's a sense that this is a place that is very different, where normal social rules don't apply, and so just being in that environment changes people's behaviour. So,
Definitely.
So duress doesn't need to mean standing over someone with a cricket bat. Duress can just mean putting someone in a situation where they believe that making a false confession is the easiest way to avoid the duress. Okay.
Yes, I definitely agree, and I can recall many situations of I was there in the capacity of witnessing affidavits, often on appeal. Mm-hmm. So their level of anxiety and uncertainty, and sometimes even learning difficulties in reading those documents, a form of duress for sure, because the path of least resistance is just to go, what have I got to do all this and read this and have this explained.
What was the level of the Indigenous prison population of Boggo Road at that time?
Majority.
All right, well, I'm going to come back to you in a moment then when I talk about other reasons for false confessions. What about promises? The opposite of duress. Could a promise secure a false confession? What do you reckon, Tiffany? Tiffany's mic isn't working. B, what do you reckon?
Well, definitely. I think in those cases where they sort of like don't give you food or water and said, if you tell us the truth, we'll let your we'll let your wife visit you, we'll let you go. That's kind of an inducement.
Yeah, I'd kind of almost think that that's more along the lines of duress, though. What about if someone came up to you and said, "Look, these three guys have well, okay. Let me give you a low-key example. Let's say there was three of you in a car. The car's flashed through a red light camera. The person who was driving the car is down to their last point. Okay, so they know that if they're driving the car, they're going to lose their licence. And they say to you, look, I'll pay the fine and I'll buy you a couple of decent bottles of bourbon if you just take the hit for this and say you were driving, because you've still got all 12 of your points. If you then turned around and said, yeah, okay, I was driving the car, well, that would be making a confession in order to gain a benefit, wouldn't it? It'd be making a confession because you'd had a promise made to you. If the person said, you have to say you were driving the car, otherwise I'm going to beat you over the head, then that would be duress. You see the difference? One of them is offering a positive benefit and the other one is making a threat. Now, other reasons for confessions that might not actually be confessions include cultural reasons. Now, other than Kelly, who I'm going to come back to on this in a moment, has anyone else heard of a thing called gratuitous concurrence? Okay. Gratuitous concurrence. I don't want to move forward in this tube until everyone knows about gratuitous concurrence, because particularly for those of you who are going to have anything to do with the criminal law, this is actually incredibly important. Within many Aboriginal cultures, and I am stereotyping to an extent here because there are many different Aboriginal cultures, but one of the common threads that runs through Australian Indigenous cultures is that when an Aboriginal person is speaking to a person who they perceive to be in authority, they will quite often say yes to things out of deference in order to be polite, not because they're actually agreeing with the thing that's being said. So you might say, if you're a lawyer or a police officer, you might say to an Aboriginal person, you were driving that car, weren't you? And they might say yes, not because they actually were driving the car, but because they're just a little bit overawed by the situation and because they're trying to be polite and pleasant. And the cultural outcome of that is that they will say yes. Now, Kelly, is this something that you came across in Boggo Road back in the 80s?
Definitely. Definitely. And I think today still.
Oh, well, look, honestly, I've had discussions with a judge about gratuitous concurrence within the last 6 months because of confessional evidence in relation to an Indigenous person. Because it's not like the Indigenous culture's changed in the last 20 years. But one of the things that did come out, because you would have been there prior to the Royal Commission on Blackness in Custody, and one of the huge things that came out of that Royal Commission was that Indigenous people, particularly when they're interviewed on their own, they're very likely to just confess to things as a result of gratuitous concurrence. And it is now clear, it is tragically and awfully, terribly clear that through the 1970s and the 1980s and the 1990s, that many, many Indigenous Australians went to prison for things that they didn't do. Because
they made it out of remand.
Sorry?
If they made it out of remand in the 70s and 80s?
Tragically, many Aboriginal people didn't make it out of remand because they died in remand. But setting aside those absolute tragedies, the slightly lesser but still very significant tragedy is the number of Indigenous people who very likely ended up in prison or otherwise being punished for offences that they did not commit. So whether you are prosecuting or whether you are defending, if you come to the criminal law in the future, it is sadly almost inevitable that you will be dealing with some Indigenous alleged offenders, because the connection between the Indigenous people and the criminal law is just overwhelming. You must be very, very careful when you are interviewing an Indigenous person, whether they're your client or whether they're your suspect, to ensure that what they're telling you is not just them agreeing with you. If you ask them to put it into their own words and what you hear are your own words coming back to you, the chances are that what sounds like a confession is not actually a confession at all. It's an Indigenous person who knows that they're in a world of trouble, trying desperately to be as polite as they possibly can. And it's very easy to misinterpret. So your homework for this week, even if you only have 5 minutes to do it, is to go and do some Googling about gratuitous concurrence and find out about it. Because in terms of part of CQ Uni's mission being an indigenisation of our curriculum, gratuitous concurrence is really something that you can't go back. That you can't go through the the process without learning about. Now, Vivian, tell us about children with brain injuries. Have we got we've got your mic working because you answered the question before?
Yeah, sorry, I just had to find the right switch because I was on the chat screen. Generally, I've got 2 children with brain injuries, and basically what they do is when you're talking to them, their complex reasoning isn't working properly, so they just say what they think you want to hear, if that makes sense. Like if you say, go and do this, please, and they'll say, okay, and then they'll ignore, just sit there and do whatever they're doing, if that makes sense. They fulfill the expectation, but they don't actually comprehend what you're actually saying.
Yep. And anyone else who's got any other sort of, I guess, cognitive issue, and let's face it, one of those cognitive issues is just simply being a child. So having a not yet fully formed brain may well be at risk of being pushed or bullied into making confessions that are simply not true. So what we can start to see from all of this is that we've now got layers upon layers, haven't we? Because we've got this starting position that hearsay is objectionable. See you later, Margie. We've got the starting position that hearsay is objectionable. Then we've got this exception that says, but hang on, confessions are okay because confessions are more likely to be reliable. And now we've got exceptions to that say, actually, there's a whole bunch of confessions that really aren't all that likely to be reliable. And those include confessions that have been obtained by force, confessions that have been obtained by promise, or confessions that might be the result of cultural or other similar factors. Okay, so I guess that's a good start in terms of what the rationale is for all of this stuff. How can you make an admission or a confession? Obvious way is words, yeah? If you say, oh, I did it, then that's pretty clear. What are some other ways in which a person can make a confession? Martin says actions. Tell us about that. And sorry, before you do, Peter, have you got the, can you just post in the text box the link to that case? Because that's come out of the notes, hasn't it?
Oh, I'm just looking in Halsbury's.
Oh, yeah? Oh, it warms my heart.
Now that I know about it.
It warms
now that I know about Halsbury's.
Could you just post the citation then?
Yeah, no worries. I'll put the citation in.
Thank you. Now, Martin, confession by actions.
For example, by running away from the scene of a crime that you're alleged to have committed.
Okay, so that's DPP and Singh, running away. What other actions might be confessional? Running away is really the only one I can think of. Now, let's have a talk about running away. What are some reasons why a person might run away from the scene of the crime? Well, one obvious one is because they did it and they don't want to get caught. Okay, that's the first one. Morgan, I haven't picked on you at all. What do you reckon? What's another reason why someone might run from police?
Can you hear me now?
I can.
Okay. I think there was an example in the notes about people with visa issues.
Yep, but
another reason.
Yeah, okay. So generalise that the people might have an awareness of having done something completely unrelated to whatever it is that police are investigating that makes them not want to be around police. So maybe it's visas. But if I can think of some others, back in the I believe it was the early 1990s, but it might have been the late 1980s. in London, there was a serial killer going around. And this serial killer was particularly attacking young gay men. And police were having all sorts of problems trying to undertake this investigation, because basically young gay men at that time in London saw police as a threat and wanted to have nothing to do with police. So if you're from a marginalised community, like in that case, young gay men, and you saw police coming on, wouldn't the first thing on your mind be getting out of there? What if you were standing outside a nightclub and you and 3 friends were passing around a blunt? Don't do drugs, by the way. Drugs are bad. But you're standing outside the nightclub passing around a blunt and someone gets stabbed. And at the time that the cops come running because there's been a call because someone gets stabbed, you're standing there holding a joint. Are you going to hang around? There's a pretty decent chance that you're going to do a runner, isn't there? And you got nothing to do with the stabbing at all. You just don't particularly want to have a conversation with police with cannabis on your breath. Vivian's added another one to the list there that's very obvious, which is running away from danger. Someone pulls out a gun on the street, I'm out of there. You know, people can make what they like of the fact that I'm running, I'm getting out of there. So there's the first concern that I have about action as a form of confession, is that actions are quite ambiguous. But the second problem I have with actions is that if I give evidence that I saw Martin running away from the scene, how is that hearsay? Because I've seen that with my own eyes, haven't I? Why isn't that just primary evidence of something that I've seen? And then if we want to establish why Martin was running away from police, well, we have to call him, don't we? We have to put him on the stand and say, why were you running? And if we can't find any other evidence, well, we've got no evidence. All we've got is evidence of him running. And as we'll find out in a couple of weeks' time, that's circumstantial evidence. And we might combine that with other evidence to show that he was running for a reason which suggests guilt. But I don't see why this needs to be part of hearsay at all. Having said that, the authorities in DPP and Singh say that you can make a confession by actions. I'm not so sure. What if a person's signing? Anyone know Auslan? What if a person doesn't communicate orally and they're signing? What do you reckon in that case? Is that a confession by an action, or is that a confession by words? Martin says by words. Anyone else? I've completely stumped you all, haven't I? It's a confession by words. It's simply that the person is communicating their words using a non-verbal means, using Auslan. It's exactly the same as writing things down. And Tiffany's asked why it matters. Well, I think it kind of does matter because I think most judges see confession by actions the same way I do. And so you're much more likely, if they're words, which they are, then you're much more likely to have to start thinking about the hearsay rule. Confession by silence. Confession by silence. Can you confess by silence? Martin says not in Queensland. Tell us about that, Martin.
I'm not quite sure if New South Wales passed it, but I'm pretty sure there was at least some talk of basically making it so that if an implication could be made into your silence, same as in England.
What do others say? what I say is we should be dragging out our Evidence Act to see whether there has indeed been a change. Let's do that. Let's pretend for a moment that you can confess by silence. Anyone uncomfortable with that? B's nodding away. Why are you uncomfortable with that, B?
Well, I think it's a general rule that, you know, you're entitled to remain silent in a criminal trial. So if now you're going to say, oh, if you remain silent about something which you're supposed to know about, then you're in essence confessing to it. I know there's this Weisensteiner direction that the judge is supposed to give. That I think is somehow a bit prejudicial actually to the accused, because it said that by remaining silent, you know, the jury is allowed, it's not a confession, but the jury is allowed to draw some conclusion from it.
That's amazing, B. I wasn't expecting any student to throw Weisensteiner directions at me. Let's talk about, now that it's come up, let's talk about the Weisensteiner direction, because it's really, really interesting. What's called the Weisensteiner direction is a direction that a judge can give to a jury in a criminal case, and it's a direction that's only given when the defendant has elected not to give evidence. Okay, so the defendant has relied on their right to silence. Now, the idea of a Weisensteiner direction is sometimes you're going to get a situation where evidence that might exonerate the defendant, can only come from the defendant themselves. I'll give you an example. Let's say the defendant is, well, okay, this is a contested example in the authorities, but it's a really good example to help understand the Weisensteiner direction, so cut me a bit of slack. Let's say that the defendant has a really unique tattoo, and the tattoo is in a place that most people in daily life don't get to see that tattoo, and that the person who committed the offence was wearing only underwear, and so what the witnesses who saw the offence have said is that the defendant, or sorry, that the criminal, the person who actually committed the offence, has no tattoos on their arms or no tattoos on their body. Now, our defendant could prove their innocence just by taking their shirt off, couldn't they? And showing the tattoo. If they choose not to, the Weisensteiner direction says that it's okay for the jury to start speculating about why not. Now, the Weisensteiner direction only occurs when the evidence that would be given by the defendant is uniquely within knowledge of the defendant. Okay, but let's come back to confessions by silence. The classic case was where a dude hit a child with a vehicle. Mum, of course, went Burko and was screaming at him words to the effect of, "Why did you do it? We've been telling you to be careful or else something bad would happen around there." And instead of answering her, he remained silent. What's the problem with silence like that?
I think there's enough bad feeling going on in that situation. No matter what you say will probably inflame it. So just being quiet is probably the best thing to do anyway.
I was once at a party where it was a party of a group of people who, let's just say, it wasn't my usual set of people. And I was in conversation with someone who had clearly had a few too many Bundys, and who was telling me, using very colourful language, how disgusting he felt gay people were. And I said nothing. And the reason that I said nothing was because I was so furious that whatever I had said when I opened my mouth, I was going to end up regretting. Now, he probably walked away from that conversation feeling like I agreed with everything he said. Okay, because people take that silence as concurrence sometimes. In fact, when someone's silent, you don't know what's going on in their head. You see what I'm getting at? That silence is inherently ambiguous. There could be any number of reasons. Fear, anger, or even just a sort of an understanding that when you're in trouble, particularly with the criminal law, you just don't say anything. Okay, these are reasons that people might be silent, and that it might not actually be confession. So what I would suggest is that be aware that there's this idea out there of confession by action and confession by silence. But realistically, the most reliable confessions and admissions are going to be those that are given by words. Now, a couple of things have come up in the chat that I want to deal with before moving on to anything else. And the first one was from B, who asked about admissions by conduct and why they're called admissions rather than confessions if they came from a criminal case in the DPP and SING. That actually happens quite a lot. That rules for hearsay generally, but in particular rules for confessions. They come out of criminal cases, but then they're applied to cases more generally. So that idea of confession by conduct it's not limited to the criminal law. It's theoretically possible for somebody to make an admission by conduct in exactly the same way in a civil case. And I actually think in a civil case, it's more likely that you might find situations where somebody makes an admission by their conduct. But I'm trying to think of an example, but let's say somebody was using a piece of heavy equipment and they did so in a way that made it abundantly clear that they had no idea how to use that piece of heavy equipment when they told everyone that they could. That almost starts to look a little bit like an admission by conduct, doesn't it? But it still suffers that same concern that I have, which is I'm not sure that it's hearsay at all. But that's the reason, B, is that it comes from the criminal law, but it's applicable to both the criminal and the civil law. And Martin has talked about shows like The Bill. He's talked about English cop dramas. I think there's only one English cop drama worth talking about, that's The Bill, where they say in their sort of arrest statement, their standard arrest statement in the UK, they say you have the right to remain silent, but it may harm your defence if you fail to mention anything which you later rely on in court. Now, that's actually lines up with a different hearsay exception, which we'll talk about in next week, which is what we call prior inconsistent statement. So if a person has the opportunity to tell police about something initially and they refuse to do so, and then they later on, sorry, not prior inconsistent statement, recent invention. So let's say you've got the chance to tell police about something at the time of your arrest. You don't say anything. And then 12 months later, when your matter comes up before the criminal courts, all of a sudden you remember all these details that you didn't talk to police. Well, it's going to be pretty obvious for the prosecutor, isn't it, to say, well, hang on, you're just making this stuff up. You didn't put any of this in your statement. You refused to give a statement. This is all just made up. But it is all of that stuff, all of that police cautions is all very much around trying to make it clear that the police are not in the game of giving either inducements or threats to people to make confessions or admissions. So, so that's, I guess, where that's coming from. One last thing that I want to talk about before we get to 8 o'clock, and there's this silly thing that keeps going around, and it just doesn't seem to die even after all these years. This ridiculous suggestion that somehow if you apologise, that's the same as a confession. If you have, in particular, this happens when you have a car crash, and you still see, things that say, well, what to do in a case of a car crash. Number one, do not apologise because you'll be accepting legal liability. What an absolute load of nonsense. An apology is not a confession or an admission. Okay? It's just not. An apology is accepted and understood as being a kind of normal social nicety. Now, having said that, apologies are certainly not confessions in torts matters, which is the main time that it comes up. So things like car accidents. Apologies can be reasonable evidence in criminal matters. So, for instance, let's say that you're a police officer and you arrive at the scene of an incident where a driver has hit a child on a bicycle and the child has quite clearly died. And the driver is on their knees on the side of the road, sobbing their heart out and saying, I'm sorry, I'm so sorry, I'm so sorry, over and over and over again. Is that confessional? People are saying no. Why don't I play the devil's advocate for a moment and say, well, I think that might be confessional. They're saying pretty clearly that they did it, aren't they? What do you say, Jess? You were shaking your head no?
I think that's a pretty normal response if you've just killed a child with your car. You would have some sort of guilt, whether it was your fault or if the child ran out at the last minute. I think that's a normal human response.
Spot on. Spot on. The mere fact that a person feels responsible for something doesn't necessarily mean that they are responsible for something. Now, most of you know that I have quite a background in coronial law, and that means that I've had the unfortunate necessity on quite a number of occasions of having a witness in court where I've had to talk to that witness about the fact that they have killed somebody. Usually not in a context where they intended to. And very often not in a context where they were going to face any criminal responsibility for it. And let me tell you, each one of those people will probably think about the person that they killed every day for the rest of their lives. Each one of those people is fundamentally damaged by grief that will never go away. Okay, regardless of whether they were responsible or not, it's terribly normal to feel a level of upset and to feel responsible for things that you might not be responsible for at all. On a much less tragic scale, haven't we all sometimes felt responsible for things that might not have been our responsibility at all? Haven't you all kind of maybe somebody's organised a party for you and you don't really feel like going to the party on that day, and so you go along and try to pretend to have fun because you feel like you're responsible for doing so, even though it was never your responsibility to organise the party? Do you see what I mean? Like, there's all sorts of social circumstances in which we take on responsibilities for things that we're not actually responsible for. So bottom line is, I think there are some good reasons to regard apologies as never being confessions or admissions. Having said that, remember at the start of the term we talked about facts, information and evidence. An apology might well be good information, even if it's not going to ultimately be evidence. All right, we've done a really wild gallop through confessions and admissions, but and it really wasn't structured like the tutor I'd intended. But sometimes that's the way that that these things go organically, and that's why I like having tutes where the students get to sort of fashion the pathway as much as I do. Does anyone have any burning questions about confessions or admissions that you've been waiting to get answered on the way through and that hasn't happened yet? No? Excellent.
Oh, sorry.
No, go ahead.
I was just thinking about confessions and the Cowan case, which was the Daniel Morecambe case.
Yep.
And I was just wondering what your take was on that appeal when about the confession being admissible. I still struggle a little bit when I look at Swaffield, when you've got an undercover police officer and that not being admissible, and then you've got an undercover police officer in this case, and it was allowed. I just wondered what your take was on it.
Now, sorry, I'm just trying to open up the relevant legislation so that I make sure I don't steer you all on the wrong track. But under the, I'm pretty sure it's the Police Powers and Responsibilities Act in Queensland, there are things that they call control operations. And, oh gosh, this act is huge. You can find the provision for yourself. I'm 99% sure it's in the Police Powers and Responsibilities Act. But what happens is that the police can obtain essentially a warrant or an approval to undertake a controlled operation. And in the course of that controlled operation, police can assume identities, okay, and police can also engage in offences, in limited offences. So a police officer, for instance, who's assumed an identity might do a drug deal with the intention of subsequently arresting the person that they do the drug deal with. Now, the thing with controlled operations is they can't just be done willy-nilly. Okay, they have to be done. There is a sort of a process to go through for them. And the sting on Peter Cowan was most definitely a controlled operation. Now, when you look at the recording that was made of the big crime boss meeting, of the supposed big crime boss meeting Peter Cowan, and Cowan confessing during that, I think at some points the police sailed close to the wind, but I really don't think they pushed him into the confession in a way that was improper. I really feel like they said to him, look, if you want to be part of our gang, we need to know about any bad stuff in your history that might affect us. Is there any bad stuff in your history that might affect us? We've heard that it's been suggested that you did this to this child. And ultimately Cowan said, well, yeah, I did. I guess at that point it's up to a jury to look at what's going on that camera and say, well, do we believe this confession? You know, do we think that this confession was secured by police asking tricky questions, or do we think that this confession is actually the proper evidence of the person? On that basis, I think I'm okay with it. But the reason that I am speaking so hesitantly is that the power to do this, the power to assume identities and to move among the community and for police not to tell you that they're police, that's a power that would need to be exercised really, really carefully. Martin's posted the link to Chapter 11 of the PPRA, which has those provisions in it. So maybe one of the things you can do is go and have a look for yourself and see whether or not you feel as a citizen of Queensland that you're getting sufficient protection from those provisions of the PPRA. My sense is that we probably are, but that this is an area where we as the legal profession need to remain really, I guess, vigilant in terms of making sure that this is a power that police use for good and not in order to secure convictions where there's no conviction truly to be had. That was a very long answer to a short question, wasn't it, Melissa?
No, that's okay. It's interesting, and being such a recent case, even more so. Yeah. Essentially, those controlled operations rules can pretty much change everything. I'm also not convinced of whether that video recording, I mean, obviously it's documentary hearsay, but it's only documentary hearsay. So as soon as you've got someone who can authenticate the document, well, then it can just be played to the jury, can't it? You know, I mean, it's not as though they had the police officer who played the big boss trying to come into court and give evidence about what Cowan had said to him. What Cowan was saying was right there on the tape that could be played to the jury. So, yeah, I don't know. I'm really glad that bloke's in prison, and that sort of ends up shaping my view about the way that he got there. But I think that there are some reasons to make sure that we maintain a certain amount of vigilance about how police use such an extraordinary power. Okay, it's about 8:10. I'm going to call it quits for tonight. Hope that was useful to you all. Look, because of the way the last couple of weeks have panned out, I'm a little bit behind on my Moodling, so I'm going to make every effort that I can to try and catch up. But I do drop by and keep an eye on the answers that people are making to those tube questions, and it's good to see that it's so active. So you can look for some more responses from me in the next very short while. Until then, I will see you all next week.
Thanks, Anthony.